Hello, everybody. Welcome. Thanks for joining us today. My name is Mike Gibb. I run accountsrecovery.net, and I want to welcome you to today's webinar on credit reporting and bankruptcy. Credit reporting and bankruptcy in and of themselves are two of the trickier topics for companies in the accounts receivable management industry. And when they collide together, it makes for an even bigger set of problems. Today in this webinar, which is being sponsored by TCN, we have a panel of credit reporting and bankruptcy experts here to talk about the pitfalls you need to watch out for and how to address these important topics within your organization. Before introducing the panel, I wanted to take a quick second and talk about the accountsrecovery.net Slack channel. I'm just putting a link in the chat window that you can use to click on to join it. If you haven't joined the Slack channel yet, I encourage you to do so. We're more than 600 members strong, using it, the Slack, to stay in touch with one another, interact with one another, network, ask questions, get answers, really just sort of use it to stay in touch, and a great way to communicate with one another. If you haven't joined the channel yet, I encourage you to do so. Again, it's completely free. Now what I'm going to do, we're going to start our discussion in just a couple of minutes. But before I do, what I want to do, I'm going to try something a little different today, and I haven't told the speakers about this yet, but I want to give them a chance to introduce themselves. Just talk for 30, 45 seconds or so about each of you, and then we'll get to our discussion. But before I do that, let me get through the rest of my housekeeping items. Our format today is going to be a panel discussion. We encourage everybody to submit questions, and we'll get to them during the course of our conversation today. To submit a question, you can do so either via the Q&A tab on your Zoom webinar control panel, or send it to me, or send it to us through the chat window. Before bringing on the panel, we're going to be talking about compliance today, so let me read the following disclaimer. This presentation is not intended to be legal advice and may not be used as legal advice. Legal advice must be tailored to the specific circumstances of each case. Every effort has been made to ensure this information is up to date. It is not intended to be a full and exhaustive explanation of the law in any area and should never be used to replace the advice of your own legal counsel. Now let's go around the table, the panel, and give each of you a chance to introduce yourselves. David Anthony, we'll start with you.
Hey, I'm David Anthony with Troutman Pepper. I'm in their Richmond, Virginia office, and I regularly handle national work for the debt collection industry for FDCPA, FCRA, TCPA, and other consumer claims.
Excellent, thank you. Alan?
I'm Al Hockheiser, Maurice Witcher. I'm located in the Cleveland, Ohio office. I've been practicing bankruptcy law for 30 years, representing creditors in defense matters and other areas in bankruptcy and also commercial collections.
Excellent, thank you. And Iris?
Hey, I'm Iris Kwan. I'm with Tromberg Morrison Poulin. I practice bankruptcy law. I currently am at a creditor's firm, but I have practiced in debtors work for a few years as well. So I'm excited for this webinar. Yeah.
Well, thank you very much, each of you, for joining me today. Really excited to get to what I'm sure is, what everyone considers to be the sexiest of sexy topics, credit reporting and bankruptcy. So let's sort of dive right in, and let's start by talking about the rules that are in place for when reporting debts for someone who has filed for bankruptcy protection. What would you say that people are sort of absolutely need to know about this process? And Al, we'll start with you.
Okay, well, I think the first thing that everybody needs to know first, and even before we get to the credit reporting piece, is when bankruptcy is filed, you have that automatic stay in place. So everything stops at that point in time. Your collection activity needs to stop. And failure to do so is going to keep attorneys like myself, David, and Iris busy defending you for stay violations. But one of the hotter issues that has been coming up and what we have been seeing is more and more complaints filed because of credit reporting issues. And it makes a difference when you're looking at the credit reporting is at what point in time and how you're handling these obligations. Is it just as soon as the bankruptcy is filed? How should that be reported? Do you report it included in bankruptcy? Do you stop reporting? The second piece of that part is, what do you do when the case is discharged? How do you report that? And those are the pieces that we're going to talk about today. And I think when you look out there, when you're looking at the rules on reporting, what you need to do is first, when the bankruptcy is filed, is mark it as included in a bankruptcy. Okay, that is the first piece that's out there. Whether it is a Chapter 7 or a Chapter 13, the key to prevent yourself from being sued is to make sure that there is an accurate report going to the credit bureaus as to the status of the debt. Does that mean that you need to change the status of the debt, what it was prior to filing? So if you're dealing with a delinquent account, do you show it not delinquent now? Or do you have to zero out the balance while it's in a bankruptcy? And these are all pieces out there of things that we're going to need to look at, and we're going to talk about it today. So that's the general overview of just when we're looking at reporting, what to do as soon as it files in the bankruptcy. And I'll pass it along to either Iris or David to add some thoughts on that as to the specific rules.
Yeah,
this-
that was, oh, go ahead, David.
Go ahead.
Well, I thought that was a great toucher on bankruptcy, and yes, the automatic stay goes into place. Another point of reference is the FCRA. That is the credit reporting rule. It's federally enacted, and just like a little primer, bankruptcies can't remain on that report. The most stringent standard is for 10 years. So it's interesting just to keep that in mind when noting certain debts that will be placed on a consumer's credit report.
Yeah, and I have probably 3 rules that I would mention. Number one, I have a lot of clients that choose not to do credit reporting once bankruptcy hits. There's not a right or wrong answer. All I would say is that bankruptcy is very complicated and can be tricky, and the credit reporting can be tricky in of itself. So you marry the two together, and that's, you know, trickiness squared. And so there are some clients that choose not to do that. All I would say is if you are going to credit report bankrupt accounts, just understand that those accounts tend to be more complicated. And if you can't do it well, don't do it. Just as a reminder, under the Fair Credit Reporting Act, unlike the Fair Debt Collection Practices Act, there is no cap. You have unlimited liability and you can have punitive damages. And a lot of debt collectors just sort of assume that their liability is going to be capped at the FDCPA limit. And they're in for a rude awakening oftentimes when that happens. So that's point number one. Point number two, following up on one of Al's points, but I really want to emphasize it, is be accurate. And, you know, I think everybody probably says, oh, of course I'm going to be accurate. Well, understand, what does accuracy mean in bankruptcy? You know, for instance, I've had cases where the amount of the charge off is different than the amount of the demand letter is different from the bankruptcy claim. And so then, you know, what is it, the amount that is reported as owed on the credit report? And so, you know, to the extent that you're going to mischaracterize something in bankruptcy or overstate it, we see people do that lots of times, either because they're not as familiar with it, or frankly, some of the situations are a little bit dicey. So accurate. While, you know, it's not safe to say that you will never be liable for accuracy problems if your reporting is accurate, because there can be some rare instances where something accurate can still be misleading. Generally speaking, that's a safe harbor to make sure. And how you report accurately in bankruptcy is not easy. The third sort of line of demarcation for me is whether you're talking about something pre-discharge or post-discharge, and understand the distinction between that. There's some different rules that go along with that. And we see claims that fall into both buckets. You know, it's very typical to see a post-discharge bankruptcy claim where something is still credit reported that was discharged in the bankruptcy. For the plaintiff's counsel, that's pretty low-hanging fruit. So, you know, as Al mentioned, you know, don't forget that your obligations continue, you know, to report the information accurately. And so we see that as being a stumbling block. So those are 3 things that I would encourage everybody to keep in mind to try to stay safe.
And one thing I'd like to add on that, because you were talking about dischargeable versus non-dischargeable, I think also when you look at the CDIA manual, one of the issues that they pick up on is a pre or post petition debt, because there's, you know, even though a debtor is in a bankruptcy, it doesn't mean that they're not able to get post-bankruptcy filing credit or obligations that are out there. And as a creditor who has a post-petition obligation, you may be reporting that, and your rules are going to be different because that is a debt, especially in a Chapter 7, that is collectible if the debtor defaults. You don't have issues, though you may have some issues with the stay if the case is still pending and you want to collect on it. But the way you report that, definitely different than the way you would report a pre-petition debt. And the other thing that the CDIA manual talks about is what do you do about long-term debts, the difference between debts in a 7 versus a 13? Because as Iris knows, because she represents mortgage creditors out there and other secured creditors, you may have debts in a Chapter 13 that are long-term obligations that are continuing to be paid by the debtor as the case is going on. How do you deal with those, and how do you report those? Are they different? But again, it goes back to the common theme that all three of us are talking about, is you need to be accurate because the FCRA says if you're not accurate, that's where your problems occur.
Okay, we've got a few questions that have started to come in, so I'm going to use this as an opportunity to address those now, but also to remind everybody watching and listening, if you have a question for our panel, send it to us through the drop in the chat, or send it to us through the Q&A, and we'll get it asked and answered.
Mike, let me add one point real quickly for the first question, because again, I think this is really worth emphasizing. Understand as well that within the credit reporting system, who you are and where you get the dispute is critically important. If you are a consumer reporting agency, right, you have an affirmative obligation to report that information accurately. As a furnisher, somebody who provides that, you likewise have that obligation, but it doesn't create a cause of action for the inaccurate reporting. It's only when there's been a dispute. So, the lesson we always tell all the furnishers is, you certainly want to try to do your best to make it accurate. But when you get a dispute in bankruptcy, you really ought to try to fine tune to get that one right, because if you get that wrong, that's when you can have liability.
Okay. Some of the questions that have come in, sort of the first question, I'll summarize a few questions, and that sort of seems to be the vibe of why bother. It doesn't, based on what people are hearing and seeing from so far from the panel, doesn't seem like there's a tremendous amount of benefit to credit reporting, either sort of during or after bankruptcy. Are there any use cases that any of you can make for what the benefits might be to do so?
I would say twofold. Number one, if you were to ask the CDIA, they would say all this information is important to create someone's credit profile. The second thing is that most of my clients who do it believe that they get a better return for they're having credit reported than versus not having credit reported. But it raises a really important point, Mike, which is if you're on the fence about it, or you're not committed to getting it right, having somebody who's a master of the Metro 2 system, don't do it.
And the one thing that I would add on that, and I was going to talk about it a little later in regard to reaffirmation agreements. One of the thoughts out there is, as David brought up a bit, is with the return. And if there's a chance for secured creditors to obtain reaffirmation agreements, get the debtors continuing to pay, let's just say on a car loan, so they don't need to go repossess their vehicle, or the debtor stops paying, is there an advantage to doing the credit reporting and assuming the risk, because you're having dollars come in? Now, there's a recent case out of Toledo, Ohio, Northern District of Ohio, where the bankruptcy judge actually denied a reaffirmation agreement, almost sanctioned debtors counsel on the case, because one of the reasons that the debtors attorney signed off on that the reaffirmation agreement was in the best interest of the debtor was because it was their belief that that would help improve the debtor's credit going forward. Okay, that case, and it was a national credit card issuer in the case, and it actually also makes secured loans. The court actually brought in an expert from the bank to testify, and that expert said it really isn't advantageous to the debtor because, yes, it may move the credit bureau a tiny bit, it may help establish credit somewhere far down the line, but the risks if the debtor defaults under the reaffirmation agreement is much greater than the benefit that they would get from positive reporting of a reaffirmed debt. So you take the risks that the creditors may have from reporting it wrong and the debtor's not obtaining much of a benefit out of it. It all depends, what the underlying philosophy of the creditors and the debtors are. And if courts are going to stop approving reaffirmation agreements because they don't think it's advantageous to the debtor from a credit standpoint, then, we may have to look at this whole process. And I know we're going to talk later, and it will be a good topic then, talking about with Reg F, and that's out there, and some of the commentary that came in about the debtor's credit. But when we get to that piece, we'll talk about it later on.
And just to continue on with what the benefit is to the creditor to report these debts to a credit reporting agency, I mean, like Alan said, it goes down to the values of the creditor and see if they can use and list these debts as a form of leverage to incentivize this consumer to basically pay off their debts, because it is hurting their credit report if there is a legitimate debt that's being accumulated and not being paid for. And if this consumer is trying to look to purchase a home or do a big purchase item and they need a certain credit score, they're going to be incentivized to try to pay off the loans that are hurting them most. So every little bit of non-payment would hurt them and may incentivize them to make that repayment. So at the end of the day, is the benefit worth the cost? It's up to you at the end.
Yeah, and one other thing that I'd add, because the most common other reason that I see our clients reporting bankrupt accounts is because their contracts require them to do so. If you think about it from the creditor perspective, it's easy for the creditor to think, I'm going to get more return on my dollars if you credit report. And they don't say, including in bankruptcy, they just say you must credit report. And so if you want to collect on accounts from this particular creditor, then you've agreed to credit report. And so you then are swallowing the bankruptcy FCRA conundrum as part of that obligation.
Just going to hit the pause button on our discussion briefly because of what I'd like to say a few words about TCN, the sponsor of today's webinar. TCN is a global provider of comprehensive cloud-based call center platforms for enterprises, contact centers, BPOs, and collection agencies. A couple of weeks ago, it announced the launch of TCN Operator, its next generation of its flagship platform. Built for the modern call center, TCN Operator features an intuitive interface and comprehensive set of easy-to-use automated agent tools and advanced apps that all work together to boost agent productivity and improve customer experience. TCN Operator's features include omnichannel communications via voice, email, and SMS text that provide a seamless, unified experience for call center agents to interact with customers on whichever channel the customer prefers. Business intelligence, reporting, and analytics that provide a 360-degree view of call center operations to identify anomalies or trends and generate actionable insights. Data management and compliance tools that ensure adherence to TCPA, FDCPA, and other state and federal regulations, including new and updated debt collection rules issued by the CFPB. Workforce engagement to manage all aspects of call center operations, including scheduling, forecasting, onboarding, and training, evaluating performance and productivity, and resolving customer and agent conflicts. And seamless integration and automation with third-party services and applications, automating key tasks, including automatic dialing, predictive dialing, IVR for routing calls, and interactive voice messaging. Grounded in TCN's deep understanding of call center needs, TCN Operator is built on the company's vast experience in supporting billions of interactions every year between call center agents and customers. For more information, you can click on the link that I just put in the chat window to learn more about TCN Operator. Thanks again to TCN for sponsoring today's webinar. All right, we've got a few more questions that have come in here. Here's one. If it is not a joint filing, can we still keep reporting the spouse, and how does the stay impact the case?
Okay, well, I guess I'll start with that. And it all depends on what chapter was filed. So
Okay.
if you have if you have a chapter 13, there's a potential of a co-debtor stay. Okay, and if I understand the question, the spouse, if you have one spouse on and you have the other, you have the bankrupt debtor and you have a co-debtor stay in place. Okay, I think the reporting that's going to be out there is you can't collect, you're getting paid through the chapter 13 proceeding. It's an unsecured debt until you move for co-debtor relief. If you're not getting paid 100% out of the chapter 13 plan, I think the way you have to report is that that debt is included in the bankruptcy. But is that really accurate as to the non-bankrupt debtor spouse? And that creates some issues for me, because are you reporting it correctly if you say included in bankruptcy, but if you're reporting a loan that now is growing more and more delinquent because it's getting paid in the chapter 13, is that an accurate reporting? So I think that's a tough issue.
Yeah. In a chapter 13, it's definitely more of an issue. With a chapter 7, the co-debtor stay is not in effect. So, I mean, arguably, if the debt is split, it does raise a lot of questions, doesn't it? Because how do you pro rata split that debt between the filing debtor and the non-filing co-debtor? In a chapter 7, it raises a lot of issues as to how to accurately label it on the credit report. But as a safety measure, probably listed as it's in bankruptcy, and then proceed further into it to see.
Yeah, I can just say that, I agree with Iris and Al's comments. This is not a common FCRA claim I see. We tend to see, routine, this was not included in the bankruptcy discharge, it should have been, you haven't reported it accurately, as opposed to this scenario.
Okay. Here's another question. If you're going to report, the CDIA guidelines say you can report the consumer information indicator to reflect the bankruptcy status once, and then only report a value in that field when something changes. Or you can report the status of the bankruptcy each time you report. Is there an advantage to either approach? Are you open to more liability with the first approach if the credit reporting agency does not update the credit report?
I'm a little confused by the question, but I would say this. If you are updating the information as you receive it and it's accurate, that's better than not updating the information and relying on old information. That's my general rule.
That makes sense.
And the thing that I would add there is, so you report it once and then again you report the change. There's an interesting twist in some cases, what we see in bankruptcies now. And if you're not reporting on a regular basis, what do you do in chapter 7 cases, and that's typically where you see it, that get closed without discharge? I haven't seen really any FCRA cases, come out, but that always perplexed me, because there are times that debtors don't complete their consumer education courses. They have to take one in the beginning right before they file, and they have to take one during the pendency of the bankruptcy in order to receive their discharge. So now you're reporting on a chapter 7, that is included in bankruptcy. Okay. Then you get a notice that the bankruptcy case is closed without discharge. Okay. So now you can technically treat that as a dismissed bankruptcy, a long-term debt that is going on that you could still collect. But what we see probably 70% of the time is the debtors then go back in, take their consumer credit class, the debtor's attorney files a motion to reopen the case, and moves for discharge, and then the discharge goes on. So if you're making the reporting at that point in time, you're reporting and included in bankruptcy, then you're reporting a debt that basically is live again, but then you have to go back and then report it as discharge. So to me, I think you report every time there is an event. And I think it's a safe way, as David says, rather than just sitting there and relying on what goes on in the case by not doing your updates. And especially if you don't get notice. So.
I agree. It's definitely more prudent to list the changes, so long as they're accurate. But when I was doing debtors work, I did notice a lot of the credit reports, a lot of creditors would actually, as Alan mentioned, close out the loan just upon the petition filing, which doesn't actually discharge a debt and technically is not accurate. Although the harm to the creditor and just wait in removing the debt at the time of bankruptcy filing will not necessarily subject them to litigation, right? Because the consumer is happy it's going to be removed from their credit report. But what does hurt them in the creditor in the long run is if the discharge order isn't entered. I think a lot of creditors don't want to keep that maintenance of accurate reporting with on the loan, because let's look at it. There's probably really big portfolios with a lot of loans. The maintenance may be difficult, but the accuracy of it is important to, ward off any litigation. So yes, I did see that quite a bit when I was practicing as debtor's attorney. A lot of creditors will just close out their loan, but it's really applicable at the time of discharge order or upon stay relief order. So.
Yeah, and I always am concerned about, systemic issues. And so, there is, when you have a policy that essentially says we're going to not report, consistently as we receive information, but rather, under some other set of circumstances, most of the bankruptcy cases where I see it's where somebody missed something, right? And their system was not in place to catch it. And if I had to err, I would err on the side of a system catching everything as opposed to having a system catch some things, because I think that's more difficult to manage.
Okay. Moving on to our next question. Where to go here? Here it is. Is there a required time frame to either delete the reporting from the credit or to accurately report the account as in bankruptcy? Is that just whatever cycle you normally use when you're furnishing your information? You just have to follow that as well for bankruptcy cases?
Ordinarily, the requirements for a furnisher to report information, in a reasonable time period, there's not a set time that goes along with that, and so, a lot of the clients that I work with, do bankruptcy scrubs or things like that to check to make sure before they proceed. And then, presumably they've gotten notice, whatever. I think the question also can be looked at, differently from the perspective of the most critical time period for the FCRA space for furnishers is after they've received a dispute through the ACDD process that's gone to the CRA. And in that situation, the reasonable investigation must occur within 30 days. And so that's one that if you do not meet that, you can have a failure to reinvestigate claim for failing to do so within 30 days. And one issue I'll just kind of tease real quickly is that occasionally we've seen situations where the client, whether because of COVID or something else, has challenges in completing their investigation within 30 days. That's a whole different conversation. But if you understand that, really dissect this, that you've got the duty to provide accurate information, but it's not really actionable until you get the dispute. Don't miss your 30-day deadline for reinvestigating a disputed claim.
Okay. Moving on, our next situation. This scenario happens a lot. Please help. Buyer 1 files Chapter 13. The co-buyer does not. We report ECOA code of T for the non-filing party. 6 months later, while the buyer is still in an active Chapter 13, the co-buyer files a separate Chapter 7. Since the co-buyer is showing as terminated from the account, is there a reason to report the new Chapter 7?
I think, Iris, you might want to address this. It sounds like that this client does what Iris was suggesting, in that when buyer one files, they go ahead and terminate the rights of buyer two. That's the way I understand
Yeah,
it.
exactly, David. So with the creditor, that this is probably a creditor that has not wanted to take the measures to consistently update the account upon the initial debtor filing for bankruptcy. They probably just want to terminate the account and not be liable for any updates or failure to update. At that point in time, it's essentially at the creditor's decision if they want to update the account. The prudent answer is to conform to the FCRA and yes, update the account appropriately. But is it going to be actionable, on a practical level? Probably not, because both consumers are happy that the loans aren't going to be on their credit report, and there's no actual damages that they're incurring from that type of activity. But prudently, yes, it should reflect correctly as to what the actual status is, which is it's not terminated upon the second filer's Chapter 7 bankruptcy filing. It will be terminated upon the entry of discharge order. So.
Yeah, I'll just add one comment, and that's this. Under the CDIA requirements, and furnisher is supposed to report information as accurate, conduct its investigation. If the account's accurate, continue to report that way. But as Iris said, if you look at it through a risk lens, a furnisher is never going to get sued by a consumer after receiving a dispute and deleting the trade line. So that is a compliance tactic by some folks, particularly for these thorny issues. Is they do the best they can, and if they get a dispute, they delete the trade line, because then that cuts off their liability that goes along with that. They have to deal with that in terms of their creditor and explaining how that all goes, because sometimes that doesn't sit well. And that certainly is contrary to the general obligation to report information accurately. But realistically, that is an approach that some people take to mitigate risk.
I agree with both of you. I don't see a need to report it once it's terminated. The risk level should be minimal.
Okay. I'm trying to think if we asked this question. In the Chapter 7 asset case that has received a discharge and the case is still open, is there an obligation to report the discharge, or can the creditor wait till the case is closed?
The rules actually require it to be entered upon entry of discharge. I mean, there is that time frame, but entry of discharge, that's the specific order, that's a specific timeline that will indicate that the loan has terminated and that they cannot collect upon it. So.
And then there's a part 2 to that question. If a reaffirmation is executed and filed and is past the rescission period, but not yet discharged, should reporting resume, or should reporting resume once the case is discharged and closed?
So my view on that with the reaffirmation agreement, the rescission period is 60 days from the date of filing the reaffirmation with the court or approval, or the discharge is greater. So if you don't have the discharge in place, there's still the ability for the debtor to rescind the reaffirmation agreement. So I don't think you can report that as a reaffirmed debt moving forward because that rescission is out there. I think you open yourself up to some risk, except for the fact that the debtor probably wants it reported, okay, because they are making payments again, which goes back to what I mentioned way in the beginning. How do you deal with just either voluntary payments being made or long-term payments in a Chapter 13, how you report those on the credit bureau. So again, reaffirmation agreements are really a different species once you get in here, because there are so many things. I mean, I think it becomes clear you can start reporting if you choose once the rescission period has run. So it's either discharge or that 60 days from the filing / court approval. But otherwise, you just have an obligation that the debtor's making voluntary payments on. And can you report voluntary payments in a Chapter 7? I don't think you can, because if you do, and what happens if they default? Now you're going to show them as defaulted. They had no requirement to file to make a payment on that at all.
Okay. We have a few questions related to bankruptcy and the FDCPA. We have one where a plaintiff's counsel files an FDCPA claim for a violation of the automatic stay, but the debtor did not list the debt in the bankruptcy petition, so no notice was provided. How are we liable and how best to respond?
Arguably, when the debt is not listed on the petition, it's not dischargeable because it was improper notice. So that would be my first argument, and I think that would probably be the strongest argument.
Yeah, we've had those claims before. And in fact, what we've argued is that the plaintiff's counsel can't have it both ways. If they do have an FDCPA claim, that FDCPA claim belongs to the trustee, not the plaintiff's counsel. If the plaintiff's counsel has it, but it wasn't raised, then we would argue that there's no violation because you haven't violated the stay that goes along with that. And this is not an unusual situation. And, and I don't necessarily fault the bankruptcy lawyer, the FDCPA lawyer, because I think that sometimes plaintiffs just don't tell their client, their lawyer, everything. And then they get a demand letter after the fact and they go, well, I filed for bankruptcy, and, the plaintiff's counsel goes ahead and files that. But we see those claims pretty frequently. Yeah. So whenever you have an FDCPA case involving somebody who's filed for bankruptcy, check to see if he's filed for bankruptcy, he or she, and get a copy of the schedule. That should be your routine practice.
Yep. And then, the other thing that I always bring up in these situations, and what's frustrating, is that the FDCPA counsel, without reaching out to the creditor or creditor's counsel, they go ahead and on day one, they file these claims because they got the demand letter or they got the lawsuit that was filed. But they don't go back because they're separate from the bankruptcy attorney and they don't look at the schedules. Or number two, when you have a debt buyer situation, a debt purchaser, okay, and even everything was done right and the, goodbye letters and the hello letters are sent, they're running a credit bureau, okay? And that's how a lot of debtors' attorneys fill their petition. They don't ask to see all the bills or all the letters that the debtors are getting, unfortunately, and they just go off the credit bureau, and the debt buyer is not listed. They don't get notice. So as Iris said, technically they're not included in the bankruptcy. It's going to survive discharge, but they get that letter. You have your defenses there. I mean, we see way too many of these claims, and they're well defensible.
I will
it's
say,
also
sorry, go ahead, David.
Go ahead.
So the notice aspect of it is really important, right? So if you're going to argue that you weren't listed on the schedules and you didn't have notice for the bankruptcy and that therefore you're not liable for the these claims, just make sure that a proof of claim isn't filed too, right? Because that would actually indicate that there was notice once you file a proof of claim in the bankruptcy. So as long as you didn't have the notice in place and not have anything else contradicting it, I think is just a point I wanted to make.
Yeah, and I wanted to make a different point, which is just sort of a general practice point, which is we see a lot of folks in the debt collection industry that are very accustomed to getting a dispute under the FDCPA, but they're not accustomed to seeing disputes under the FCRA, and they confuse the two. And they respond to one, but not the other. And so, you need to understand the distinction between a dispute under the FDCPA and a dispute under the FCRA.
Okay, a couple more FDCPA questions. If the debtor fails to list your client as a creditor, then tells you it should have been included, are you obligated to report it?
Well, it depends upon, to me, what you mean by you tell, right? I mean, because there's not many bankruptcy judges that are going to give a rip about anything that's not in the bankruptcy schedule. So, in that situation, I'd be more inclined to say, put me in touch with your bankruptcy lawyer and communicate with them to say, are you going to amend your schedule or you're not going to amend your schedule? I wouldn't just take the consumer's word for it, but I will tell you that you obviously have some notice of a heightened risk, and given the risk here, getting clarity is probably a good thing.
Okay.
And practically speaking, for instance, if you assume this goes forward, the judge is going to bust the chops to the plaintiff's counsel. Do whatever you want to do, include it or don't include it, but don't come in and fault the creditor when you've made the choice to play games here.
Got it. Alan, you teased Regulation F a little earlier, so let's circle back and spend some time on that. You know, maybe you could talk about some of the changes that are coming in Regulation F that furnishers need to be aware of.
So the first piece out there, and there's a lot of commentary in the proposed Regulation F dealing with the credit bureaus. What they're looking to do is not as drastic. It's more of a notice situation. So the concern out there is about passive debt collection, where there's reporting to the credit bureau. Debtors, you know, these days are looking, or individuals these days, consumers are looking to credit bureaus more and more. You know, you see all the commercials out there for free credit score, you know, request your bureaus, make sure everything's okay. Now you can go rent this new apartment or buy this new car. And so they're looking at it. So there has been this passive debt collection where there would be reporting to the credit bureau, and in order to sort of pressure, you know, debtors to make payments. Well, one of the new proposals in Reg F is that debt collectors will be unable to provide a trade line to the bureaus without first notifying the debtor, whether it be by letter, by phone call, by email, or even by text, because that's going to be, you know, potentially a new wave of the future. And giving, if it is by mail, a reasonable time for the debtor to have that information, so that way they are aware of this obligation out there. A lot of the commentary on this deals with the fact that because of the sale of a lot of obligations, that debtors really don't know what are out there. There's older debt out there that still may be within statute. The debtors aren't aware of it. And this is going to give the debtors an ability to, you know, react to these and learn about these obligations. So that's pretty much one of the main areas in the new Reg F, or the revised Reg F, that deals with the credit bureaus. And it's going to be a requirement that the debtors be put on notice before a creditor or a debt collector takes action against the debtor on that obligation.
Iris, David, anything else you want to add on top of what Alan started talking about with respect to Regulation F?
Yeah, I mean, it seems to try to become a more efficient process, but in exchange for efficiency, maybe certain parties may not have the time to be notified and refute certain reportings. So it's going to be interesting to see how it unfolds in the future. Yeah.
And I would just add that, you know, the pulse of the more progressive politicians and regulators tends to shine a brighter light on credit reporting, and tends to think that there may be some implicit bias in the credit reporting system or in the underlying data. And so what I think is likely to happen is that we're going to see more issues like what Al talked about as it relates to consumer credit and how things get reported, because I do think that they are looking at the impact of some of these things, you know, and that can come in a lot of different ways. So, you know, for instance, there has been specific credit reporting guidance provided under the CARES Act in the mortgage context. And so, you know, I know a lot of plaintiffs' counsel that I regularly deal with are licking their chops, waiting for the foreclosure moratorium to lift and all the bankruptcy that's going to come out of all of this stuff and all of the mismatched credit reporting that's going to come as someone is trying to navigate through all of that. So, you know, 2 years from now, I predict we're going to have a flood of COVID FCRA litigation while everybody's trying to figure out what to do.
We anticipate that as well, David. I mean, right now, bankruptcy filings have been lower over the past year. I think it's down by 38%. Because of the CARES Act, less people are incentivized to file for bankruptcy because they have the protection from the CARES Act moratorium and in the foreclosure process. But when this lifts, we're expecting a huge flood of bankruptcy filings. And I think a lot of the clerks and courts are actually a little nervous about what's going to be coming up, because how is everyone going to handle this volume? Basically, it's going to be a huge flood. So I think being diligent at this time while the wave is low is probably best practice as well. Just making sure everything is set up so you can hit the ground running when the wave really hits.
And what I will add is that in March and April, when you look at the consumer filings, they have started to tick up. So we're starting to get there. And I think part of that is also not because we still have the moratoriums in place, but you're also seeing courts open up. So when state courts open up, now you're seeing more wage garnishment, bank attachments, debtors exams being going through, and also if there are trials and things like that. So you're getting to judgments. One of the things, though, we are seeing now is just because bankruptcy filings are low, is that it doesn't cut off the activity, because what we're seeing is trustees, debtors' attorneys trying to become more creative in ways to generate revenue. Okay. They're getting their attorney's fees in these cases, if they're prevailing or if they're settling them. So during this slow time, and unfortunately, we've had clients who've been involved in cases where the debtor's attorney said, I've been thinking about filing this type of action. It wasn't an FCRA action, it was a FDCPA action and stay violation action. Which wasn't very clear, but he goes, we had all this time to go back and look at all our Chapter 13 cases, and now we're filing these actions. And he's filing them in district court, not in bankruptcy court. So, a lot of things happen because of COVID, and just because it's slow, creditors can't, let their guard down. And the point that Iris brought up and David brought up, look ahead, because it is going to get worse. And once you get inundated with the cases, you have to make sure your processes are in place and they're running efficiently, because from where you might be at 100 cases a week, all of a sudden you're going to be at 500 cases a week. And if you're not reporting correctly, you're going to end up opening yourselves up to some exposure.
Yeah, and I would also encourage you to pay attention to the infrastructure bills and for the stimulus bills that are being thrown around. The Democratic House passed the HEROES Act early in COVID that didn't go anywhere in the Senate. But if you read it, there was significant provisions in there dealing with credit reporting, and as opposed to modifying the Fair Credit Reporting Act, it's in a standalone bill. It's not going to surprise me, as has been the case with a lot of these bills, that they become a progressive's wish list of throwing in this and that. And so, it wouldn't surprise me to see other COVID-related categories of debt other than mortgage that get folded into some type of credit reporting requirements that I think will be different. So don't just breathe a sigh of relief and say, I don't do mortgage, I'm good. The others may be coming.
No, and if you go back, you mentioned the HEROES Act, and even though it didn't make it through the Senate, this is just how broad terms that they use. And in the HEROES Act, it was you cannot you cannot do an adverse reporting based upon a major disaster, but they never define major disaster. And that's the thing that leaves open to the courts. And I know one of the things is, where do you look for your guidance? Okay, is it from the FCRA? Is it from the CDIA? Is it from court decisions? Well, when you're looking at courts, you can get a wide variety of decisions, and even within the same circuits or even within the same district, because you have different judges with different views, and they will define, in this case, major disaster differently. They may define debt that includes, mortgages and auto loans, but doesn't include medical and student loans. And we know that there is a lot of proposed legislation and a lot of talk on student loans out there to basically wipe them out. And that's a whole different, topic We can do a webinar forever on those. But, you know, to be careful, as David said, they're adding these as tag-ons to bills, and they're trying to pass these at the last minute. So it is a good warning that David and Iris put out there.
It is interesting because I'm starting to hear sort of anecdotally from different companies across the industry that, you know, they're starting to see a drop off in placement volume. They're starting to see fewer accounts that are being sent to them by their clients and creditors. So I'm wondering if this increase in bankruptcy filings that each of you are expecting, you know, might not be as far off in the future as people think.
Well, then I'll just add one thing that, you know, complicates all of this, because like, let's pick a mortgage for a minute. You know, the CDC issued a moratorium on evictions. And, you know, a lot of people said, you're the CDC, what gives you the authority to do that? And, you know, at least one court has said they don't have the authority to do that. But I can also see, you know, an expansion under, you know, similar executive authority, either by the president, by executive order, or by the CDC, or by somebody else doing some things. And then, you know, for clients, it's really challenging, because on the one hand, somebody said this, but is it really something that governs me or doesn't govern me? And that sausage doesn't get baked or doesn't get made overnight. You know, one other point that I think Al raised that, you know, to me is a critical compliance tip. Don't be a fool and find one decision from one court that you like and say, hey, this is great, I'm going to adopt my entire policy by a district decision in Alaska, when there may be one in Toledo, or there may be one in your own court that goes differently. And I see so many clients, they are eagle-eyed about the decision that goes in their favor, and they sort of discount everything else, you know, and as Al said, you know, that's not a prudent strategy. You know, you do want to look for one that would be applicable to you. And, you know, we routinely see clients who don't do that.
Another question that came in with respect to Regulation F and notification of before credit reporting. What if the consumer moves and leaves no forwarding address and you're not able to reach them by any other means? How can you still, you know, does Reg F still require contact to be made before reporting? I think that would fall under the reasonable amount of time provision, right?
I think that falls under that, and the way, yeah, and the way they defined it, you had to make a good effort attempt.
Right.
Okay, and you did. So, you know, the risk is, to me, lower. It's not saying that a debtor's attorney, plaintiff's attorney is not going to come around and try to sue you on it, but I think the risk is low.
Yeah, and the realistic answer to that too is, you know, the clients that I represent in the debt collection space have no desire to not be able to find and communicate with the consumer. So most of them are interested when they've moved, and if, you know, they send them a letter and they come back, I don't think most of them are going to sit back and say, well, I can just credit report in the meantime. They're going to go do skip tracing or something else to try to see if they can find where that person is.
And as with a lot of the things we've talked about today, and on a lot of the compliance webinars, it comes down to sort of documenting your policies and documenting your efforts, and sort of having policies and procedures that sort of lay out, in the event you do get sued, you can show what efforts you made. I think that would be helpful too.
Well, and Mike, that's, you raise a really good point, because just as a reminder, under the Fair Credit Reporting Act, having reasonable policies and procedures can be a defense to a claim. So it's not only a good business practice, it can literally be a defense to that. And I can't tell you how many times I have clients who have had repetitive problems, and they have little to no policies that go along with that. So, you know, putting your compliance hat on, give some wind behind the sails and some resources to have appropriate FCRA policies and procedures, because they can literally matter.
Excellent. Another question: does a debtor need to include an existing claim in their Chapter 7 or Chapter 13 schedule as an asset or claim? If not, is the claim waived?
The answer is yes, they must list it as an asset. And our defense that we have raised at times is, yes, you waive that right. And there is some case law out there to support that. And, you know, number one, it belongs to, in a Chapter 7, If it is a pre-petition FDCPA claim, it belongs to the estate, and the trustee should be proceeding on that. And that's one of the ways that, you know, if in fact there is a true violation is listed, get the trustee involved. You have a much better chance of getting it resolved with the trustee because his interest is the estate, okay? And it's not just the one debtor, and they're always willing to reduce amounts on settlements in order to get some money for the creditors, which normally wouldn't receive any at all. So, yes.
Okay.
I agree 100%. You know, again, best practice, get the bankruptcy schedule, look at your notes, compare what it was, see what happens. And again, I think Al raised an interesting point that we're seeing more claims of earlier in his remarks, which is, you know, don't be meticulous in checking, because there are post-bankruptcy filing extensions of credit. And so we've had claims where the creditor is, the furnisher is accused of an FCRA violation by including something in the bankruptcy that wasn't in the bankruptcy, as not being accurate and harming them because it gave the appearance that their credit score was lower than really what it was. So
When you mentioned being meticulous and checking, David, is there a sort of a frequency guideline or rule of thumb that you would advise?
you know, certainly before you take steps, you know, check the, you know, if you've got a bankruptcy vendor that checks, but the, you know, PACE report, all that stuff is available. I mean, generally speaking, under the FCRA, 30 days is a good solid default rule. You know, it's not a set it and forget it kind of statute. And again, I would also, you know, have red flames coming out that when you get a dispute, different animal. So a dispute under the FCRA is a pre-litigation demand. So just, you know, you can't be liable for until you have that happen. So I view it as a different category.
Okay. We've got a couple of minutes left before we wrap things up for good. I wanted to give each of you a chance to sort of share any parting words of wisdom, any concluding remarks, any other advice or perspective you didn't get a chance to talk about today because the conversation just didn't head in that direction, but just to give each of you a chance to have a last word. So we'll go around the panel, and Alan, we'll start with you.
The only thing that I would add or harp on again is be accurate and be responsive. If you receive a notice from the bankruptcy court or you receive a notice from a debtor who's raising an issue as to the stay, as to credit reporting, be responsive to it and don't let it sit, because that's where these cases start to go south.
Thank you. Iris?
I agree with Alan. Also, because this is kind of a lull period, I would just say put your practices in place right now, make sure they're ironclad, review all of your policies and compliance issues, not only for the upcoming flood that's going to come, but also just because, as previously mentioned, more people are a little bit more litigious. They're going to nitpick on certain things. So you just want to make sure you're protected as much as possible. And this is a great time to take care of that. So.
Excellent. Thank you. David?
I agree with both Al and Iris's points, and just want to highlight two things. First of all, my recommendation is to always put your best, you know, person in charge of handling your FCRA disputes, not your worst, because again, it's a pre-litigation demand, and reaching out to the consumer and trying to do that in an intelligent, meticulous way is money well spent. The second point, you know, talking about a theme that we've talked about, you know, if you assume that all hell's going to break loose, not for too long in the sense when we get back to normal, and also assume that the trend is more towards more careful scrutiny of credit reporting. And if you assume by progressives, which I think will happen, and if you assume that the complexity of bankruptcy and FCR interplaying is going to continue to trend to being more complicated, that's a confluence of a storm coming. And, you know, use the opportunity now to prepare for that, because I suspect there'll be a whole rash of other issues when we do this a year from now, where all of this stuff has started to settle out a little bit. So said differently, don't assume that 2021 is going to be like 2018 for all of this stuff. There will be more of it and more complicated versions of it and new issues. And so guard yourself accordingly while you have time to get ready for it.
Excellent. Well, Iris, Al, David, thank you so much for your time and your insights today. Really appreciate you sharing your wisdom with the audience, but also answering as many questions as you did sort of on the fly. That was really nice and really appreciative. So on behalf of everybody listening and watching, thank you very much. Want to thank TCN one last time for sponsoring today's webinar. Check them out at www.tcn.com. Please share your thoughts in a survey that'll pop up on your screen when I end the webinar today. Also give you a chance to share any topics you want to see covered in another webinar in the future. So always helpful for those suggestions. I'm always grateful for those. We're back tomorrow. We're trying something new, a new series that I'm launching called The Talk Off. There's a link to sign up on the events calendar for accountsrecovery.net. Looking forward to seeing everybody then. Until then, everybody, thank you very much. Stay safe, stay well. We'll talk to you soon. Panel, excellent job. Thank you so much.
Thanks for having us. You all have a great day.
Thank
Thanks
you.
now.